registration for early hearing, when the applicant is undergoing treatment in suffering from cancer. I pray for the application card.
Criminal appeal. Which year? 22. Why it will be hard? 22. Why it will be hard? Old appeals are pending.
The lady applicant is suffering from cancer. She is undergoing treatment in Tata Memorial.
Paper book might not have been prepared. So you file your paper.
File an application for early hearing. You have to ask it that the official paper.
Okay, that listed that for early hearing, so that you are to prepare the paper book, because nowadays this Xerox copies are coming, original are not coming. So
Vigilance appeal 2017. Paper, I file a miscase for ready of paper book, my lord. Ready of paper book, I file a miscase, my lord. I file.
You want to prepare the paper book and file it.
Cost of the land.
My lord, JCRL 78 of 16, my lord. For fresh admission, my lord, not at admitted, my lord.
Why?
It has not been admitted till
admission in
the brother of the appellant has been expired on 27th March, my lord. The brother of the appellant has been expired, my lord, on 27th March, my lord. I have filed an interim application for release on in bail, my lord, interim bail, my lord. Kindly today, my lord.
We'll see it tomorrow.
Tomorrow, my lord, tomorrow.
Surrender certificate has been filed by me. Surrender certificate has been filed with the appeal, man. And all the courts are again released on a interim bail. My IABV listed, madam.
Yeah.
I don't to mention that criminal conviction appeal fresh admission.
My lord, one tied up matter, my lord, directed. Another is conviction, my lord, 5 years remaining.
My lord, BLAPL 10272 by 23. My lord, date was posted to 11th March, but not listed.
What is the number?
BLAPL 10272 by 23.
Okay, noted down.
Thank you, my lord.
Weekly list item number 1.
May I please, Lord, it's a vigilance conviction matter. Page 74 is the hearing on sentence, wherein the present appellant has been convicted for 3 years for the offence under section 13(2) read with 13(1)(d) of OPC Act. Your Lordship got it, page 74, Your Lordship. Running page 74 and internal page 62 of the judgment.
So the maximum sentence is 3 years.
3 years, madam. And the appellant was all along bail during trial.
You are not arrested, though. What is the question of as it appears date of arrest not up? Yes, Mr. Das.
Yes, my lord. Other 4 co-appellants have already been released on bail by your lordship. All of 2024, 157, 162, 191, 197.
Likhitale chapter number. Please tell once.
157, 162, 191, 197.
All of 24.
Yes, my lord, all of 24.
All right. Hard admit call for the trial court record. Mr. Sanjay Kumar Das, standing counsel for the Vigilance Department, submits that this criminal appeal is connected to CRLA number, CJO chapter number. Henceforth, the matter be listed along with so and so.
LCR has been called for in 157.
Before call for the trial court record, before the registry shall verify the availability of the trial court record in the aforesaid 4 files, before calling for this. Bail, he was on bail allowed, stay realization of fine, free copy of the order be handed over, and he'll file the appearance memo. Yes.
By the end of June, my lord.
Yes.
Obliged, your lordship.
Item 2.
May I please your lordship? The appellant in the present appeal challenges the order of conviction under section 20B subclause 2B of NDPS Act, sentencing him to undergo rigorous imprisonment for 3 years as well as imposing fine of rupees 25,000.
You were on bail during.
Yes, your lordship.
What is the quantity of?
Quantity 4 kg 900 grams, your lordship.
Yes, Mr. Das. I'd admit he was on bail, and bar under section 37 not applicable in view of the quantity seized. Bail allowed, stay realization of fine. Yes.
Obliged.
Item 3.
May I please, Lord? Petitioner has been convicted, my lord, on under section 20B 2B of NDPS Act, my lord. And my lord, conviction is under for 3 years, my lord, and fine for.
What is the offense you said?
Offense, my lord, under section 20B 2B of the NDPS Act. Fine.
And the sentences?
Sentence is, my lord, for 3 years and fine of 1 lakh rupees.
And you are on bail during trial?
No, my lord, bail has been granted, my lord, on 22/2. Before the bail order has been executed, bail order has been placed before the law and trial court on 26th. In between that, during verification of antecedent, and the order of final order of judgment has been delivered, my lord.
Okay.
My lord.
So you have not availed the bail order?
No, this is the copy of the order, my lord.
Okay, it's all right. Sentence is 3 years.
3 years, man.
Yes.
Memo
Huh?
appeal memo debe.
Achha. Let a copy of the appeal memo be served on the learned counsel for the state. What is your good name?
Debasis Patnaik.
Mr. Debasis Patnaik. And admit, call for the trial court record. Submit that in view of the quantity of ganja seized. What is the quantity?
4.5 kg.
Bar under section 37 not applicable. And he was on bail. Katti debe, seta lakhi he's in custody since
15/11, my lord.
15/11/2023. There is no chance of early hearing. Bail allowed. Stay realization of fine. Obliged.
Item 4.
May I please, your lordship? The conviction matter, your lordship, vigilance conviction, my lord. Page 51 of the judgment, your lordship, running page 67. Page 51, my lord. Judgment, my lord. Paragraph 2. Now, conviction, my lord, under section 7 of the PC Act, 3 years, and section 13(1)D, my lord, 4 years, my lord. And the sentence shall run concurrently, my lord. And he was on bail during period of the trial. And after judgment, my lord, in custody, man of 66 years old, my lord. And the trap amount is 2,000, my lord.
You were on bail during
trial.
Yes, Mr. Das.
Yes, my lord. He is in custody since the date of judgment, my lord. 23/3/2024.
All right. I admit Sanjay Kumar Das submit that he will file the appearance memo.
By the end of June, my lord.
Interim application. He was on bail, but after conviction, he has been taken into judicial custody. Bail allowed, stay realization of fine, free copy of the order be handed over.
Obliged.
Obliged.
Item 5.
Petitioner laws in FIR 14/9/2000.
What is this defect number 7, Mr. Sarma? Defect number 7, acha. It is a SC/ST bail matter.
Yes, it's not bail.
Then what is it?
First, a GR case was instituted. A GR case ended up in final form, stating that no case is made out, and on the date of occurrence, the petitioner was not physically present at the site. Then a protest petition was filed, and the witnesses who had given 161 statement stating that no case is made out, nothing, they're deposed. Basing on that, the cognizance has been taken, and now the complainant has been noticed. He is not appearing, before your lordship. He has been noticed. Notice has been served.
So you have got your papers, Mr. Das? Yes. So what is the FIR? Let us see.
The FIR is an external. The allegation is that, while the principal was sitting inside his chamber, I went inside him and abused him in filthy language. Then, witnesses.
Who has lost the FIR?
The principal himself.
Name.
The complainant number 2. Sorry, the opposite party number 2 in this case.
Gopal Chandra.
Gopal Chandra Behar.
Who are you in that college?
I am a reader, So he lost a FIR that I went inside his chamber and abused him in filthy language. So a GR case was instituted. 161 statement of the witnesses were recorded. 161 statement of the departmental official and staff of the college were recorded. Your Lordship may see page 17. He's a junior clerk of the college.
No, you come to the statement of that informant, Gopal Chandra Behera, which you have annexed as annexure 2 series, page 16.
Yes.
ଆମ କଲେଜର କେମିଷ୍ଟ୍ରି ଲେକ୍ଚର ଆମକୁ ଅସଭ୍ୟ ଭାଷାରେ ଗାଳି ଗୁଲଜ କଲେ ମୁଁ ପ୍ରତିବାଦ କରିବାରୁ ସେ ମୋତେ ଜାତି ଉଠାଇ ଶଳା ଶୁଆଂଶ ଅସଭ୍ୟ ଭାଷାରେ ଗଳେ ପାଟିତୁଣ୍ଡ ଶୁଣି so yes, so that she has stated about this.
Next witnesses, 161 statement. Next page, Next page, ଦୁଇଙ୍କ ମଧ୍ୟରେ ଯୁକ୍ତିଚର୍ଚ୍ଚା ହଉଥିଲା ମାତ୍ର ଆଲୋକ ପ୍ରଧାନ ଅସଭ୍ୟ ଭାଷାରେ କିମ୍ବା ଗୋପାଳକୁ ତାଙ୍କ ଜାତି ଉଠେଇ ଗାଳିଗୁଲଜ କରିବାର ମୁଁ ଶୁଣି ନାହିଁ। ପରେ ଜାଣିଲି ଗୋପାଳ ଥାନାକୁ ଯାଇ ଆଲୋକ ପ୍ରଧାନଙ୍କ ନାଁରେ ଏତଲା ଦେଇଛି ସେ ଅଭିଯୋଗ କରିଥିବା ଘଟଣାଟି ସତ୍ୟତା ନାହିଁ।
Okay, she ଶୁଣିନି
but next page, next another witness. ଅପରାହ୍ନ 5:10 ସମୟରେ ପ୍ରିନ୍ସିପାଲ ସାର୍ ଙ୍କ ଅଫିସ ରୁମ ସାମ୍ନାରେ କୌଣସି ଗଣ୍ଡଗୋଳ ହୋଇନାହିଁ କିମ୍ବା ଆଲୋକ ରଞ୍ଜନ ପ୍ରଧାନ ଉକ୍ତ ସମୟରେ କଲେଜରେ ନଥିଲେ। This is important, my lord. ପ୍ରିନ୍ସିପାଲ ସାର୍ ଓ ତାଙ୍କ ସହଯୋଗୀ ମାନଙ୍କ ବିରୁଦ୍ଧରେ ଆଲୋକ ରଞ୍ଜନ ପ୍ରଧାନ କେସ୍ କରିଥିବାରୁ ସେମାନେ ସମସ୍ତେ ମିଶି ଉକ୍ତ ମୋକଦ୍ଦମା ଆଲୋକ ପ୍ରଧାନ ନାଁରେ ଦେଇଛନ୍ତି। So prior to this FIR, my lord, I lost one FIR which has been registered, investigation has been completed, and charge sheet has been filed against this person and 2 other lecturers, my lord. So as a retaliation to that, this has been filed.
So why final report was submitted?
Yes,
what is that?
Your lordship may see the final report, my lord. Page 24, my lord. Last paragraph, my lord. During the course of investigation, I examined the complainant and recorded a statement under 161 CRPC, visited the LS spot and prepared the spot map. I examined the chance witnesses to the LS occurrence and all the witnesses disproved the occurrence. I verified the CCTV footage installed inside the college, but nothing was found. I seized one pen drive regarding movement of alleged Alok Rajan Pradhan on the LS date and time at Omphed shop. So he was in Omphed shop, my lord.
Udala as well as neighbor house of Alak Pradhan. Accordingly, I verified the CCTV footage of Ompet shop, Udala and neighbor house of alleged Alak Pradhan and also extract the same in CD. I issued requisition to Tahsildar Udala Baripada and Baliapal for furnishing the caste particular of the complainant and the alleged person. I received the caste particular of the complainant and alleged person from the concerned Tahsildar, in which the caste of the complainant Gopal Vera is recognized as Dhobi, coming under SC category, and the alleged person Alak Ranjan Pradhan belongs to so and so, coming under SCBC category. During investigation, it is ascertained that on 12/9/2022 at around 10:30 a.m., Alok Ranjan Pradhan was in college. Informant Gopal Pradhan, the principal of the college, called him to come to +3 examination section. Accordingly, he reached there and found Gopal Chandra Behra along with Professor Bholanath Sahu and Girish Chandra Pothal and Sudhanshu Kumar Mohanty, examination section clerk, were present there. On his arrival, informant Gopal Chandra Behra, being accompanied by Bholanath Sahu and Girish Chandra Pothal, scolded him in obscene language and threatened him with dire consequences. As such, Alok Pradhan was harassed, annoyed, insulted, and defamed publicly. Basing on this incident, a written report of Alok Ranjan Pradhan Udala PS case number 281 of 2022 under section so and so was registered against Gopal Chandra Behra, Bholanath Sahu, and Girish Chandra Pothal. After registration of the case being cunningly enough, the informant Gopal Chandra Behra, under the instigation of the supporters, filed false allegation against alleged Alok Ranjan Pradhan, which is a counter case to Udala PS case number 281 of 2022. This case was supervised by so and so.
No, it's all right. So now this final report was submitted. Thereafter, what happened?
Then the informant filed a protest petition.
Where is that protest petition?
Protest petition doesn't move next for any, but I have annexed the statement of the informant.
Where is the protest petition?
200 and 202 examination witnesses, my lord.
Where is the protest petition?
So that
After receipt of the final report,
sir,
the court must have issued notice to the
yes, yes.
informant.
Petition was filed.
So where is that protest petition?
In this protest petition, man, he alleges misconduct on the part of the police. The police didn't properly investigate the case and file final form the case. Reiterating what was stated in the FIR.
So in the protest petition, whatever he has stated,
yes,
and whatever he has been stated in the initial statements, so also the statements recorded under section 202 CRPC,
yes,
whether those things make out a prima facie case or not.
But in my humble opinion, my lord, if there are only departmental officials and departmental colleagues,
no, do you mean to say that at this stage I am supposed to verify that what is his 161 statement and what he has stated?
No, you're not.
So why a chance was given to the informant if he's being dissatisfied with the outcoming of the police investigation to file a protest petition?
Yes.
So the chance that sometimes he is not satisfied, he is at liberty to either to file a complaint petition or a protest petition. In this case, he has filed a protest petition.
Yes.
And obviously that was considered, and then all the procedure has been followed. Initial statement was recorded, then inquiry was conducted under section 202 CRPC, and the magistrate is supposed to, or the court is supposed to look into only the facts stated in the this protest petition, the initial statement, and the statements recorded under section 202 CRPC. He is not supposed to see the FIR, the 161 statements, the final form, and compare it because that is not the scope at that stage.
Yes.
That would come at the appropriate stage of trial when it will be confronted to him the witness that you have not stated like this in the 161 statement. He may say that I have not at all been examined by the police. So if basing on the complaint petition, protest petition, even though prima submitted final report, then what is the purpose of this provision for filing the protest petition or filing a complaint petition if you are dissatisfied with the police investigation?
So, primary the court will say whether the case is.
Yes, you are right. If suppose in the protest petition and whatever collected during course of the inquiry, if no prima facie case is coming forth, matter is different. But merely because police submitted final report. So
what I am saying, my lord, in this kind of cases, the Honorable Apex Court recently held in a decision that attending circumstances have to be gone into by the.
No, you show me one decision where the cognizance taken in a protest petition after considering the protest petition inquiry statements has been quashed merely because final report has been submitted.
No, it is one of the ground. I am not saying merely.
Then so the prima facie case is not met.
Now the case is, my lord, since it is under 482, my lord, the Honorable Apex Court says in this kind of cases where it is fictitious, my lord, and it is
how I can know?
Because the police said on the date of the occurrence he was physically present somewhere else, my lord.
No.
He was not physically present.
So that means you are to say that whatever the court has stated in the FIR, same thing has been stated in the complaint petition or the protest petition, and the witnesses and he himself being examined, his initial statement was recorded, his witnesses have also supported his version.
But with due respect, now those witnesses, my lord, they have filed affidavit saying that we are being pressurized by the principal because he was my superior authority. We have given false statement.
What is that?
It is on.
So it is all everything is available with you. That statement who was given on oath before the magistrate, now he has given an affidavit to the to the accused that shows that how far you are an influential person. It is not the informant is an influential.
At this stage,
after giving statement in court on oath under 202 CRPC proceeding, they are giving you an affidavit that whatever I have stated before that they will be booked for perjury.
They will be prosecuted.
Then,
knowing the consequences, my lord, if they have come forward, my lord, then your lordship should weigh the case, my lord.
Don't
knowing
trace
the
it.
Consequences,
the persons who has come forward to help you, they will be booked for perjury. Then,
yes, knowing the consequences, they have come forward, and the college has also passed a resolution to that effect that it's an out and out false case. Not only me, the entire staff are saying, my lord. So these are the attending circumstances which can be gone into at the stage of 482, may not be before the trial court.
You see, a principal of a college, if he is abused with this sort of language, then
well, certainly it is not to be appreciated, my lord. It has to be condemned, but an incident must take place, and it is not been viewed by anybody, my lord. No public has viewed this incident, my lord.
At this stage, I am supposed to look into the prima facie case. I am not supposed to see whether the case would end in conviction.
Please, your lordship, whether a case is made out.
Yes.
Three STSCs are who nahi because
এই language गुड़ाको public place रे जो language लेखा है 3 SC कौन पे हबोनी?
Sir, ମୁଁ ଏଇ ଗୋଟେ sir judgment ଦଉଛି ଟିକେ sir ଦେଖିବେ
Mr. Das, these two persons, let us see that. This appellant and this respondent number 2, ask him to appear, both of them. They are one is the reader in chemistry, the other is the principal. Let us see that.
Which one, my lord? The
Udala College, both of them are
like the witness, my lord.
No. You see, this
Gopal
appellant is
Chandra-
the accused.
Gopal
Dr. Alok Ranjan Pradhan is the accused. Is the reader in chemistry in Udala College, right? The informant, who is now the
Gopal Chandra
complainant, he is the Gopal Chandra Behra, is the principal of Udala College. Call both of them through the IAC, give intimation so that they will appear on the next date. Okay. So,
Appellant they can intimate. I will intimate the Gopal Chandra complainant matter. Okay. Because notice is already served. Again, we will serve.
put up this matter on 9th of April 2024. Land counsel for the appellant shall ensure the personal appearance of the appellant in court at 10:30 a.m. on that day. The land counsel for the state shall ensure the appearance of respondent number 2, Gopal Chandra Behra, principal of Udala College, on the next date, on the date fixed. A free copy of the order be handed over to the land counsel for the state. Interim order dated so is extended till next date. Land counsel for the petitioner files the copy of the protest petition. Have you got one copy more? Give it to him, which is taken on record. Yes.
Item 6.
My lord, Mr. Ponda has requested me to take an adjournment, my lord. In the meantime, victim has been examined.
What is this matter? CRLA? Mr. Das?
307, 395, 307
for bail.
Well,
Item 7.
Yes, Mr. Chan.
here the case under section 302.
Bail matter. And you have received the case diagram. And what about notice?
Notice format.
Bail?
No bar there is.
Is it the first application? Or?
2 persons are the
Just a minute. So, since when you are in custody?
Madam, in custody, 1/5/2023. 1st of May 2023.
Charge sheet submitted under section?
Charge sheet submitted, madam. Charge sheet submitted under section 302.
Mr. Das, you are not.
I'm at 147.
Yes.
Yes, 147, 148,
323, 326, 302, 307, 153 A, capital A, 506, 149 IPC, madam. And section of 3 of the SC/ST Act. 31, read with 32, V, VA,
31,
madam. 31 R, 32, V and VA, SC and ST.
What is the name of the deceased?
Madam. Mirdha Chandravan. 2 persons are the witness.
It's a double murder case?
No, single.
Earlier, my lord, has the disposal of
No. What is the name of the deceased?
the cases, my lord.
Chandravanu Mirdha.
Chandra
Bhanu again.
Chandravanu Mirdha.
Sorry, Chandramani Mela. So I'm sorry, Chandramani Mirdha Mela.
Chandramani
Mirdha. Again.
What is the date of occurrence?
Date of occurrence, my lord, for 14/4/2023. 14/4.
There are eyewitnesses to
Yes,
the
my lord,
occurrence.
2 eyewitnesses are there.
What is the name of the
Eyewitness? One, my lord,
that
Goparanjan Sahu.
somebody is injured in this case? 326 is there.
Injury.
So name one of the person who is not only the injured but also the eyewitness.
Goparanjan Sahu is there, my lord.
Goparanjan Sahu. And one Pintu. He is the brother-in-law of the deceased, my lord. And as per the prosecution case, he was
Goparanjan Sahu is one of the person who is himself injured. And also the Pintu
who is the eyewitness.
So what they have stated against?
This is the certified copy. As per the prosecution case,
my
it is
lord,
alleged that
granted bail in CRLA 1226 of 2023.
CRLA
1226 23.
Bismaya
Behera, Bittu.
Bismaya Behera alias Bittu.
And in 3 cases, one order passed.
Common order.
CRLA 598
2023.
598
2023.
Yes.
CRLA 691 23. CRLA 821 23.
821 23.
Here, my lord, in CRLA 691, the bail application of the appellant rejected. CRLA 8
are rejected la question first time
alga co-accused release
हाँ 691 टा reject
hala 821 टा भी reject hala
अच्छा
and CRLA 598 allowed
598 टा ना कौन जे हटा Hussain Khan
and another criminal division 387 of 2023.
Just a minute. CRLREB
387/23. Teddy alias Farhan Khan. He is juvenile, my lord.
KD.
Teddy.
Alias Farhan Khan.
My lord. Juvenile, he is allowed.
अच्छा ए जो दीटा रिजेक्ट हेची 691 रे आउ 821 रे ताको ना गुडा कहले
मोहम्मद राजा हुसैन alias राजू
मोहम्मद राजा
my lord
हुसैन
my lord
आउ देखिए
आउट my lord मोहम्मद यूसुफ
81
हां 81 पूरे मोहम्मद यूसुफ my lord
अच्छा
alias मोहम्मद इसरार
अच्छा now if some of the co-accused have been granted bail, some of them have been, the bail application has been rejected. So as per the eyewitness account,
Bisma Behera is the same footing of the present petitioner.
Bisma Behera,
my lord.
And this petitioner Nahala Arbaz Khan.
Arbaz Khan.
They stand on the same footing.
I have given the statement before, my lord.
And
I witnessed it.
Any criminal antecedent?
Antecedent, my lord. He has 2 antecedent, my lord.
This Arbaz Khan. What are those cases?
Arbaz
in 307 would The other person has also with some criminal cases. That person granted bail, not of similar nature. 147,307 case, my lord.
কেবে কারো?
সেটা হচ্ছে 2021 out of 2020 র ଅଛି সেটা 323 147
What is the status of those cases?
in both the cases he is on bail.
Where is your affidavit to that effect? File an affidavit, Mr.
I'll keep maybe if I'll keep it tomorrow I can file, or
will you be able to file
mal
that? And with the copy of the bail order?
Yes, ma'am.
All right. The learned counsel for the appellant submitted that the appellant is similarly situated like the co-accused Vismaya Behera alias Bittu, who has been granted bail by this court in CRLA number 1126 of 2020.
122 1226 High
order dated 12/3/2024. The learned counsel for the state on verification of the case diary, particularly the eyewitness account of S.K.SAHOO and Pintu Boi, fairly submitted that the appellant is similarly situated like Vismaya Behera alias Bittu, but the appellant has got two criminal antecedents. One is of the year 2020, 2020, and the other is of the year 2021. And the latter one was under section 307 IPC. Mr. Chan, learned counsel appearing for the appellant, submitted that he has instruction that in both the cases the appellant has been granted bail, and he will file a comprehensive affidavit along with the bail order copies. বর্তমান কোন date কেবে রাখি?
কাল রাখলে हमको दे
certified copy of the bail order with
certified.
So you
may keep it of Monday, coming Monday.
Okay, put up this matter on 8th of April 2020. Certified copy of the bail order shall be filed, we will like them along with the comprehensive affidavit, giving copy to the learned counsel for the state in advance. এই যে কাগজ খন্ড রখি দিতে হবে গোটে হলা স্টেটমেন্ট এটা আই উইটনেস হ্যাঁ 20 ର ଆଉ ଗୋଟେ ହେଲା এটা টাউন বেস
Item 8.
Mr. Behera Vijay Kumar bhaiya.
My lord, may I pass over the matter?
Pass over matter. You have received the case diary? My lord. My lord. So it will be taken up tomorrow.
Yes, my lord.
Yes.
Item 9.
May please.
Item 14.
May I please, your lordship?
Yes.
The offense under section 307 along with other offenses, my lord.
CD available? No. SC matter.
My lord.
What about notice? My lord.
In the second case, CRL 134 2024, I am appearing my. I am filing Bhakuladana.
You are appearing for the informant.
Yes, my lord. In the other two cases, I have no interest. Let me one gap trial taking.
No, informant is the same. So what is the problem? You do freely. One case you have received your fees. The other case you do it freely. Yes, file your VNAMA. Why the case will be adjourned? You have received the copy of the appeal memo.
Yes, ma'am.
All right. So, in each of these cases, 3 cases, one appellant or
3 appellant.
Huh?
3 appellant.
I am for the last item, Lordship.
No, ସବୁଥିରେ ଜଣେ appellant ଅଛନ୍ତି ନା ବେଶୀ ଅଛନ୍ତି?
Then join.
Last are the ଜଣ. Okay. So first you tell me about CRLA. V number आइले कि informant. All right. CRLA number 131 of 2024.
My lord.
Sole appellant is Ashok Gowda, right?
My lord.
And what is the date of custody?
6/12/24. 23, my lord.
6/12/2023.
My lord.
Then we will come to the next one, CRLA 134 of 2024 is Kanhu Charan Gupta.
My lord.
And what is the date of custody?
6/12/23.
Same.
My lord.
Then third one is CRLA 212 of 2024. There are 2 appellants. Who are they?
Both are arrested 8/12/23.
8/12/2024 ନା କୁହନ୍ତୁ ଗୋଟେ ହେଲା ବାଙ୍ଗରା
ବାଙ୍ଗରା ହେଲେ ମୁନା ପ୍ରଧାନ, 2 ହେଲା ସୁଦାମ କାର୍ଯ୍ୟ।
ବାଙ୍ଗରା ପ୍ରଧାନ ଆଉ ସୁଦାମ କଣ ତା ନା?
ସୁଦାମ
ଆଚାର୍ଯ୍ୟ. Now what are the offenses under which charge sheet submitted?
307 along with other offenses, 3S
147,
Yes.
148,
Yes.
223.
Hmm.
Sorry, 323, 325,
323, 325.
307,
Yes.
149,
Hmm.
31R,
Hmm.
31S,
Hmm.
32VA,
Hmm.
32V,
Hmm.
341, 294, 506.
341, 294.
My lord, 506.
So, so far as the 307 is concerned, who is the injured?
2 injured persons there.
in front brother.
Rahul Naik.
Please, one by one. Mr. Das,
Uh,
who are the injured?
Rahul Naik and Rahul Dalabera.
Rahul Naik is one injured, the other is Rahul Dalabera.
My lord.
So, what sort of injuries they have sustained?
Simple injury, my lord.
No,
All are simple in nature.
nature of injuries.
Simple in nature.
Simple. Both are simple.
My lord.
My lord.
But on the head.
My lord.
Any
Average.
criminal antecedent?
They are threatening my lord also.
Okay, you are being threatened. All right, Mr. Das.
In item CRL 131, my lord.
Yeah.
5 antecedent.
Yes.
And CRL 134, Kanu 2 antecedent. And another other nahi aseni.
For lordship item 212 ରେ first petitioner 5ଟା antecedent ଅଛି ଆଉ second petitioner 2ଟା antecedent ଅଛି. are given the
Bangara ro hochi 5ଟା.
5ଟା
ଆଉ ସୁଦାମ ro hochi
2ଟା.
where is the comprehensive affidavit?
I have already filed.
In both the items you have filed.
22, 3, 20.
And in those cases, what has happened?
He's on bail.
He is in bail, not case.
All cases he's on.
All cases he is bail. Both are bail.
बेल ले जाएंगे नहीं सब काम करछन्ती कोन पे बेल दे जियो जाई 307 बाडे पिटे करणी कोन जन Mr. Gopal Krishna Naik, Learned Counsel, files power for the informant in CRLA number 134 of 2024, which is taken on record. Since the informant in the other two connected cases, that is CRLA number 134 of 2024 and CRLA number 212 of 2024 is the same, and the case arises out of same occurrence. The learned counsel for the appellant agreed to also make his submission in CRLA number 131 of 2024 and 212 of 2024. The learned counsel for the appellant submitted for common order karibe, gote order karibe. That the appellant appellant Ashok Gowda in CRLA number 131 of 24 and appellant Kanhu Gowda in CRLA number 134 of 2024 are in judicial custody since 6/12/2023. And the appellants Bangara Pradhan and Sudham Acharya in CRLA number 212 of 2026 are in judicial custody since 8/12/2024. And the appellants have been charge sheeted under section 147, 148, 323, 325, 307, 506, 294, 341, 149 of the Indian Penal Code, section 3(1)(r)(s) and 3(2)(b)(ba) of the SC/ST. And there are two injured persons in this case, namely Rahul Naik and Rahul Dala Behera, and they have sustained simple injuries. And therefore, the bail application may be favorably considered. Learned counsel for the state submitted that all the appellants have got criminal antecedents. Learned counsel for the appellants have filed comprehensive affidavit which indicate that they have been granted bail in those cases. Learned counsel for the informant opposed the prayer for bail on the ground that the injured persons have sustained injury on head. Considering the submission made by the learned counsel for the respective parties, the nature of accusation against the petitioner, the period of detention in judicial custody, nature of injury sustained by the injured person, I am inclined to release the petitioner, appellants on bail subject to condition that they shall not indulge in any criminal activities, they shall not try to tamper with the evidence, appear before the learned trial court on each date. Case would be posted for trial. Violation of any terms and conditions shall entail cancellation of bail allowed all the bail. এটা নিয়ন্ত্রণ রাখবে আর এইটা হচ্ছে তারও এটা হ্যাঁ এটা রাহুল নায়ক রাহুল দরবেরা
Item 15.
Wait. Yes. Now you can go.
Item 15.
May I please, Lords? SC/ST bail matter, my lord.
Mr. Das, you have received the case diary and
they gave a number. Earlier application was there 406. Let me check there. The CD may be available. And so far the notice is concerned, my lord, not received the confirmation letter, my lord.
we will take up this matter next week, my lord. Learned counsel for the state submits that the CD might be available in a connected case.
The CRLA 406 of 23.
Number
406 of 2020.
And the matter may be taken up next week. uh, so that he will produce the case diary and also obtain confirmation letter regarding service of notice on the informant. Put up this matter on 8th April 2022.
Item 16.
Mr. Bose, wait. CD available?
Ma'am,
And what about notice?
notice or ma'am? 18-3-200.
Is it the first application?
No.
So earlier application was?
Earlier application was CRLA 324 of 2023 and 311 of 2023, which was taken up together.
No. What order was passed?
That order is 3/7/2023.
Where is that order? Have you got the copy of that order?
Yes.
It was rejected.
Yes. My petitioner's appellant's case was rejected. The other case was allowed. I have marked that portion. If your lordship can see, I have folded that portion.
Okay, State Council phrased the statement of the injured Gajanan Meher, from which it appears that specific overt act of assault has been attributed against Samir Bhue, who stated to have assaulted the deceased on his head by means of a bamboo stick. And the postmortem report finding indicate that the deceased has sustained as many as 4 external injuries, and the cause of death has been opined to be head injury resulting from application of so and so blunt trauma overhead. Okay, so that was the reason why your bail application was rejected, since specific overt act of assault has been attributed against you. Then you are given liberty to renew the prayer for bail after examination of the eyewitnesses to the occurrence in the trial court. So what is the change now?
They have been examined.
Who are they?
Annex 3 series is the deposition of Niranjan Meher and one is Narayana Meher and one is Gajanan Meher.
So these eyewitnesses have been examined as PW?
PW 1, 2 and 3.
PW 1, 2 and PW 3
Yes.
are the eyewitnesses. Now what they have stated against you?
But I say I have given the documents, but in the cross-examination.
No. They supported or not?
They have supported.
And what overt act has been attributed against this Samir?
Samir, they have stated that yes.
Overt act is there.
He was hit by bamboo stick.
Okay. So you are the only person who assaulted by on the head. Okay.
Other person was also there.
No, but the
overt act was attributed to
Samir assaulted Kailas by means of a bamboo stick on his head. Yes. Kailas is the deceased.
And so for other work, that is on the Gajana.
No, that was the reason why the bail application was rejected also. So now the witnesses have supported the prosecution case and also attributed the specific overt act against you, that you have assaulted by means of a lathi on the head. Yeah, what do you say now?
But omnibus allegation is there also. But I am in custody, my lord, since 14/2/2023. And your lordship will see the cross-examination portion, my lord, at page 21 if your lordship will see.
At about 16 persons were working as laborers on the date of accident. We were working in front of the transformer. The spot of occurrence is 100 meters from a village. 7% passed through the spot. The dispute started because of my mobile, which was taken by someone. On inquiry, the quarrel started. My mobile number was such and such. I have not reported the matter before the police. The bamboo lathi was 3 to 3.5 feet long. I cannot see if it was hollow. The bamboo stick hit his scalp, causing bleeding injury on his body and clothes. The persons who helped him had also sustained blood on their clothes. Except 12 accused persons, no one else was present. We shouted for help. The villagers rushed to this place and shifted the injured to the hospital. I only know about one injury on the head of Kailas while working with the transformer. No persons of the electric department present. One electrician, namely Hari Harijan of our village, was present before. It is not a fact that there was one assault stated by Niranjan Nair. There was a dispute regarding a mobile phone, and that resulted in the same.
So how many other eyewitnesses are there to be examined?
No other eyewitness.
Huh?
No other eyewitness.
Yes, Mr.
Three persons who were eyewitness, they have been examined in those.
And how many cases you have got?
I have no case. To my knowledge, my lord, I have no other.
Antecedent not received, madam.
Is there any eyewitnesses?
Eyewitnesses so
Or
far,
all of them have been examined?
my lord.
My lord had noted those names in the order.
No. Now 3 witnesses have been examined. Are they all, or they are any other witnesses left out?
No, 3 witnesses, mainly eyewitnesses, madam.
These are the 3 eyewitnesses.
Yeah.
And co-accused, your lordship is released.
Co-accused,
yes. But everybody, to my subject to correction by my learned senior friend, one as well.
And what are the offences under which charge sheet submitted?
The charge sheet has been submitted under
section 147.
147,
Yes.
148, 302, 323. Initially was 307.
Charge sheet mu pacharji initially.
Certain mu koi dochu. Mu koi dochu.
Yes.
147, 148, 323, 307, 354, 506, 149, 302, 341, 294, 31R, 31S, 32B, 32BA.
Are the Learned Counsel for the Appellant Learned Counsel for the State, in spite of service of notice, non appears for the respondent number 2. Mr. Bose Learned Counsel for the appellant submitted that the appellant is judicial custody since 14 to 2023. He has been charge sheeted under section 147, 148, 302, 323, 307, 354, 506, 149, 341, 294 of the Indian Penal Code, 149 last pune section 31RS 32B BA of the SC/ST PO Act. Earlier, the appellant approached this court for bail in CRLA number 324 of 2023, and as per order dated 3/7/2023, taking into account the statements of the eyewitnesses and specific overtake attributed by them against the appellant in the assault of the deceased, bail application was rejected. However, liberty was granted to renew the prayer for bail after examination of the eyewitnesses in the trial court. Learned Counsel further submits that in the meantime, trial has commenced and 3 eyewitnesses, namely Niranjan Meher, Narayan Meher, and Gajanan Meher, have been examined in the trial court as PWs 1, 2, and 3. And there is no other eyewitnesses to be examined at this stage. And therefore, in view of the change in the circumstances, bail application may be favorably considered. Learned counsel for the state has produced the case diary, and after going through the same, fairly submits that all the eyewitnesses have already been examined in the trial court. And he placed the deposition of the 3 eyewitnesses. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced so far in the trial court, period of detention in judicial custody, change in the circumstances after rejection of the earlier bail application, I am inclined to reconsider the prayer for bail and direct the appellant to be released on bail subject to condition. It shall appear before the learned trial court on each date, to which the trial is posted, shall not indulge in any criminal activities, will not tamper with the evidence, violation of any terms and conditions, shall entail cancellation of bail allowed.
Can I take that and give a photocopy? I did not make a photocopy because
File the certified copy, and that this is already sealed, so it cannot be done.
all right.
Yes.
I'll
Yes.
Item 17.
May I please the lordship, my lord. The appellant is the assistant public prosecutor, my lord.
Just a minute. Yes, bail application.
Yes, my lord. Initially, I was granted anticipated bail, but could not avail that opportunity and got arrested, my lord. Last time instruction was sought for.
Yes, Mr. Dawn.
Well,
Is it your first
Yes,
application?
yes.
What is the date of custody?
15/2/24, my lord.
And charge sheet submitted. What is the case now?
Mel.
Forwarding report, he was forwarded for what offenses?
307, my lord. Uh, 341, 294, 323.
341, 294.
323,
Yes.
307,
Yes.
506, my lord.
Hmm.
And 147, 148, 149. 354B, 31R, 31S, 32BA. But so for the charge sheet, I have not received the charge sheet copy, my lord. It is the FIR registered on the.
Now, this, what is the allegation against this
So
man?
far, this is, my lord, here 4 injured persons are there, my lord. And all are simple injuries, my lord.
No, one is that a person who died, that is
My lord.
Ghoradei Bagh.
My lord.
Ghara, Ghoradei Bagh. He is the one injured. Who are the other?
Injured Pinky Bagh.
Pinky Bagh. Then?
My lord, Pinky Bagh. Multi-bag. And one brojo bag, and another.
Rameshwar bag is there.
Huh?
On the last date, I have given the certified copy, my lord.
Rameshwar bag.
They all have sustained simple injury. No, you said that this man, this appellant is a public prosecutor.
Yes, APP, my lord. And allegation against me, only he instigated.
Where is that government you have taken that he is a APP?
Also in the rejection order, it is reflected, my lord. In the rejection order.
Which paragraph?
My lord, page 22, last paragraph, 6th line. The complainant party has intentionally implicated the accused to teach lesson to him as because he is working as a APP at Borden, my lord.
And how many cases you have got?
Same incidents, another FIR, my lord. Last time I had given the FIR, my lord. It is also reflected.
Who lost the FIR, the other FIR?
Another person, my lord.
You are for the informant. What do you say? Now the State Council has produced a written instruction which indicates that the death has got no connection with the assault because the lady died on account of heart problem. She was aged about 84 years. Heard the Learned Council for the appellant, Learned Council for the state, and Learned Council for the informant. The Learned Council for the appellant submits that the appellant was the assistant public prosecutor, Borden, and he is in judicial custody since 15 to 2024. And he has been falsely entangled in the case, and accept the accusation that he instigated the co-accused persons at the time of occurrence, no other specific overt act has been attributed against him. And the injured persons have also sustained simple injury. And the investigation has made substantial progress, and therefore the bail application may be favorably considered. Learned Counsel for the informant, on the other hand, on the other date, on the previous date, submitted that one of the injured, namely Gharadi Bagh, has died. On the previous date, on 19/3/2024. And accordingly, the Learned Counsel for the state was asked to obtain instruction whether the case has torn to one under section 302 of the Indian Penal Code or not. Today, the Learned Counsel for the state has produced the written instruction received from SDPO Khairat dated 29/3/2024, which indicates that the victim, namely Gharadi Bagh, was aged about 84 years and she died 27 days of the assault, and autopsy was conducted by the medical officer CSC Borden, and in the PM examination report, the doctor opined that the deceased died on account of heart disease and she was at very old age. And the doctor further, and since from the doctor's report, it was evident that injuries inflicted on her person on the person of Gharadi Bagh during the assault and stone pelting has no connection with her death, the case did not turn to one under section 302 of the Indian Penal. The written instruction is taken on record. Learned counsel for the state also placed the injury reports of 4 injured persons, namely Bharadi Bagh, Pinky Bagh, Malati Bagh, and Rameshwar Bagh, which indicate that the injured persons have sustained simple injuries. Learned counsel for the informants, on the other hand, submitted that relating to the self-same occurrence, another case has been instituted against the appellant. Considering the submission made by the learned counsel for the respective parties, the nature of injury sustained by the injured persons, the period of detention of the petitioner in judicial custody, and progress of investigation, I am inclined to release the petitioner appellant on bail. But with usual terms and conditions to be there. Yes.
May I request my copy in course of the day?
Yes.
Obliged.
Copy by 8th of April 2024. Yes, ma'am.
Item number 18.
Item 22.
I'm just coming within 10 minutes.
Item 22.
May I please, my lord? My lord, here in this case, as per my instruction, petitioner has, after avail the interim bail period, not surrender, my lord. 26, 11, 2021, my lord.
as per order dated 26/11/2021 in IA number 1040 of 2021. The petitioner has not surrendered in the court below. In view of the conduct of the petitioner in flouting the terms and conditions of the interim bail order, this bail application stands rejected. The learned session judge cum special judge Jaipur at Koraput in TR case number 31 of 2020 shall take immediate steps in accordance with law to arrest the petitioner, and henceforth the petitioner, whenever will apply for bail, this order shall be placed on record. Yes.
Obligatory.
Item 23.
Mr. Pandal and counsel files a memo that the bail application has become infructuous. Accordingly, BLAPL disposed of. Yes, next.
Item 24.
Last occasion, your lordship was right for address verification because the petitioner belongs to West Bengal lordship.
No, it's a 2021 bail application. Why?
Already 4 years, 2 months in jail custody, lordship. Your lordship is
It's all right. It's 4 years have already passed.
lordship.
So go and apply bail application there. Bail application is 12/5/2021 rejection order.
Lordship.
3 years have already passed. Almost 3 years.
I am jail custody 4 years, 2 months. Lordship.
Renew your prayer there. The rejection order is dated 12/5/2021. If the case is still sub judice in the trial court, the petitioner is at liberty to renew the prayer for bail disposed of. Yes, next.
Lordship.
Item 25.
My lord, kindly permitted to withdraw.
Learned counsel for the petitioner files a memo, withdraw the application disposed of as withdrawn. Yes.
Obliged.
Item 26.
Lordship, on behalf of Mr. Chan, lordship, kindly be permitted to withdraw, lordship.
What is your good name?
S.K. Gowda, lordship.
Right, Mr. S.K. Gowda. Please write your name.
Lordship.
Submits on behalf of Mr. Manas Kumar Chan for withdrawal of the bail application disposed of as withdrawn. Yes.
Deeply obliged.
Item 27.
My lord, case is under section 20B2C of the NDPS Act manner, and he is in custody since 23/4/2022. Trial has been commenced, but as per my instruction, no witness have been examined.
The rejection is 22.
My lord.
April 22.
Case filing date 13/6/2022.
Huh?
Filing case filed on 13th June 2022.
Yes, that's what I'm saying. 2 years have passed, so you move here, there. Why after so many years? Look, rejection order is dated so and so. If the case is still sub judice, the petition is at liberty to renew the prayer for bail disposed of. Yes, next.
Obliged.
Item 28.
Non-obvious. Rejection order is dated 4/7/2022. Its case is still sub judice. Move there. Yes, next. Disposed of.
Item 29.
Rejection order is dated 11/5/2022. Non-obvious karegi na, hai na? Same type. Yes, next.
Item 30.
May it please your lordship.
What is the rejection order? 12/4/2021. Same order. Disposed of.
My lord, it's item 30.
Move there. 2 years have already passed. Yes.
Item 31.
Yes.
in custody since my lord. In 15 he was arrested. More than almost 8 years in the custody. This is regarding 42467
It's a OPID Act matter.
OPID Act matter. And all the
So where is Mr. Patra or Mr. Bhuiya? Mr. Patra or Mr. Bhuiya?
last evidence same thing had happened. Your lordship told me to search them there, but it is not listed for 5 months. I find 3-4 memos, and all accused, all directors have been released, and he's almost 8 years in the custody.
Yes.
And IO has also been examined. He was rejected as he was a director, but he is all the.
Just a minute. You have filed an application, or who has filed that application? One CRLMC has been filed, and
By one of the director.
that the order has been passed for stay of the proceeding.
Stay of the
So
it is continued there.
So why are you blaming the court that it is delayed and
Here it is bail application.
it's all right, but when the trial is at the stage of recording of the evidence of the investigating officer, stay has been.
Let me clarify. Out of 4 IOs, all 4 IOs were exempt. One IO subsequently
he came with a document for filing saying that these are the charges made, same charges. That we did challenge before the Honorable High Court.
It's all right. Now the matter is sub judice before this court, and this court has granted stay of the proceeding.
Right.
So, at your instance, the stay has been granted. It's not that the prosecution is in any way negligent in that the case is dragged because of the negligence of the prosecution. You have challenged a particular order, and this court has stayed the proceeding,
Yes.
right?
Yes.
So now, how many years you are in custody?
I am 23rd 5/2015. I was arrested.
You have never been released on interim
No.
bail.
8
Where is
years.
the counsel?
8 years.
Not responding probably.
So I'm listing this matter tomorrow. Ask him. Okay. Names are there.
Names are
Tell them that if
ସେମାନେ ଲାଷ୍ଟ ଥର ସେଇଆ କଲେ ଆସିଲେନି, ମୁଁ ଖବର ଦେଲି ଆସିଲେନି।
none appears for the state of Orissa, even though the names of Mr. Vivekanand Bhuya and Mr. J.P. Patra, Learned Special Counsel for the state in OPID Act matter has been reflected in the cause list. The learned counsel for the petitioner submits that the petitioner was taken into judicial custody since
23rd 5/2015.
23rd 5/2015, and since then he has never been released even on interim bail.
Interim bail was granted by my lord.
I'm telling you, don't.
Interim bail was granted, but due to condition that he will deposit money, he could not be released. He's not released.
Tell it in a frankly way. Why I'll record a for wrong statement in the order.
Interim bail was.
You should have said so.
He
Learned counsel for the petitioner submitted that though the petitioner was granted interim bail, but since he could not comply with the terms and conditions, he could not come out of the jail. So, yes, Mr. Patro, your names are reflected, you are not appearing. So, now this man is in custody for, he says that it is more than 8 years.
23/5/15.
So, and the case is now stayed because some of the accused persons, including the petitioner, have moved this court for.
Last report call for
that report has come. Report has come because one CRLMC has been filed before this court, perhaps by one accused, namely Devkumar Panda. And that CRLMC is 2795 of 23. And the operative portion of the order is that in the event the petitioner files a petition for adjournment, the same shall be considered keeping in view the pending. Accordingly, the date was fixed to 19th January 2024. And he says that that case, that is CRLMC 2795 of 2023, is still sub judice. What is your instruction?
That is still sub judice.
That is
ଆପଣ ଯାହା ବି ଅଫେନ୍ସ ହେଲା ଆପଣ 8 ବର୍ଷ ଧରି ଗୋଟେ ଆକ୍ୟୁଜ ଟ୍ରାଏଲ ଫେସ୍ କରୁଛି bail, and is it correct that he was granted at one point of time interim bail, but he could not avail the same because the terms and condition was that he was to furnish the cash security and he could not furnish it?
Which
orders? You have mentioned it in the cause title, in the averments taken, that you are granted interim bail, but
10456.
In which case you are granted interim bail?
Let's see. What happened? I was granted interim bail. Then I filed modification. Your lordship said go to the lower court for
The
modification.
number ta darkar magya. BLAPL number ta kete phone to. You have mentioned only one number. BLAPL number 10456 of.
BLAPL number 10456 of 2019.
हाँ.
সেটারে lordship was granted.
So verify what has happened. Okay. I'm taking up this matter day after tomorrow. Put up this matter day after tomorrow. About that proceeding which has been stayed by this court. The number you note down, the number is CRLMC 2795 of 2023. And in that case, the petitioner is one Dev Kumar Panda. So there, the stay order has been passed, whether it is still continuing or not. The London Council says that it is continuing. And the second thing is that about the custody that he was taken into custody on
23/5/15.
Right. That averment, of course, he has taken in the very first paragraph of the bail application. And the other thing that he was directed to be released on bail in page 2 of the bail application. See that number is there. BLAPL number 10456 of 2019. Page number 2. Order dated. So he was granted bail, but what he says that it could not be could not avail the same because of some terms and conditions. All these instructions you take it.
Day after tomorrow, I open this.
Day after.
Some siege agents.
All right. Next case.
Item 33.
May I please?
trial court. Yes.
Only lordship. Status report will be forwarded.
It's all right. You whatever you do want to do there. 2 years there that these matters are pending. I've stated that you renew your prayer there and come.
2008.
All right. Yes, next case.
Item 34.
My appearance will be.
Non-appeals কাটি দেবে তাহলে item number 28 non-appeals কাটি দেবে. Yes, item 34.
May I please? Last occasion, my lord directed to State Council to direct the IU to examine the witness of who claimed to be a
Review the status report furnished by the learned trial court, which reveals that 2 witnesses have been examined. So far as PW1 is concerned, he has been examined, cross-examined, discharged. 2, the informant is concerned, chief examination has been deferred because the accused persons were not produced in the court, and even if they are shown through VC, but it was not visible properly. Learned counsel for the state on verification of the case diary submit that it is a case of double murder, and vital witnesses are Lala, Manas, Kumar Singh, Sujata, so and so. So you are directed to appear the IU, the IAC, to receive the summons and ensure the attendance. So what happened?
We have to send letter and instruction.
What happened? Because there was a direction to the IAC to ensure the appearance. It's not that to receive the summon like a process server just give the summon. So whether an appearance was ensured in the trial court for the examination of those 3 witnesses or not.
But in the meantime, as per my instruction, I also conducted the case. One witness PW2 is cross-examination.
That is over.
Over.
Yes. So
it is a case under section 394, 397 initially. Thereafter 302. Only
whatever it may
not
be,
the double murder.
Submitted that it's a case of double murder.
No, my lord, it is.
And now the 2 eyewitnesses are still there. If PW2's evidence is completed,
my lord,
then Sujata Manjari Singh and Bhagi Bhagati Bhagat Lala Singh. So they have not been examined. It is your information.
No, they are not examined because of though FIR was unknown, no TI was conducted. Not examined.
Mr. Take instruction. I am taking up this matter day after tomorrow. The IAC will appear through virtual mode. Peruse the order dated 29/2/2024. Wherein the IAC Chaudhar police station was directed to appear before the trial court and to receive summons in respect of PW2, so also to other eyewitnesses, namely Sujata Manjari Singh and Bhagat Lala Singh, and to ensure their attendance on the date fixed. Learned counsel for the petitioner submitted that though PW2 appeared in the court and his cross-examination is over, but the the 2 eyewitnesses were not produced on the date fixed. Put up this matter on Acha, 5th kar diyan, on 5th of April 2024. The IAC Chaudhar police station shall appear through virtual mode on that day at 10:30, and answer as to why the order dated 29 and apprise this court as to why according The order dated 29/2/2024 has not been complied with. Free copy of the order be handed over to the London Council for the state. Yes.
Oblige, Lordship.
Item 35.
5 तारीख रख ले तो 5/4/2024 at 10:30. ISC Chogwal PS to appear. Yes, Mr. Samudra. Letter received from Superintendent Subjail Sonpur at Flag B. Dullabh Rajan Mishra upon file করছেন V number. Lekon peruse the prisoner's petition wherein request has been made to engage Mr. Dullabh Ranjan Mishra as his counsel. The prayer is accepted. Mr. Mishra files the V-Nama, which is taken on record. You have received the case diary?
Yes, sir.
Yes.
My last order is 9/2/2024.
9?
9/2/2024. That's address and document.
Okay. You furnish the names of 2 local sureties and their documents. The State Council verified it through the IIC of Ulunda Police Station, and they expressed their unwillingness to take the petitioner on bail. Then you are asked to furnish the names, address, and documents of 2 fresh local sureties. Okay, you are supplying today. All right. In terms of the order dated 9/2/2024, the London Council for the petitioner supplied the names, address, and documents of 2 fresh local sureties to the London Council for the state. Let the same be verified through the IAC Ulunda Police Station regarding genuineness of the bailers, their inclination to take the petitioner on bail, so also the authenticity of the documents. Okay. Put up this matter 15th Rakivi?
Yes.
Put up this matter on 15/4/2024. In the meantime, status report be called for.
Item 36.
May I please, may I seek permission for time, my lord, 2 weeks time. 2 weeks time, my lord, 6.
You have received the case diary?
Yes, OPID matter, my lord.
All right.
2 weeks time, 6.
The London Council for the petitioner seeks for an adjournment for 2 weeks. London Council for the Special Counsel for the State of Orissa is present. Put up this matter in the week commencing 22nd.
Yes, my lord. All right. Develop.
Item 37.
My lord, in this matter, I am to virtual mode. Lordship. Lordship, for the last date of hearing, that is the 14th March, Lordship had directed me to submit the local security document, and I have submitted as per the direction of my lords. My address has already been verified. The antecedent has already been verified. Only the local security verification was pending, for which I have already submitted the document, Lords.
So, what is the date of custody?
Lordship, he is in jail from 7th March 2021.
7th March
2021, Lordship. 21.
21.
From last 3 years. And out of 7, 5 are on bail, 2 on regular bail by the coordinate bench, and 3 has been released on interim bail by my lord order.
But it's all right. This man was apprehended at the spot.
Yes, lordship, apprehended on this. All the persons were apprehended at the spot as per the allegation in the FIR.
Is it the first application or earlier bail application was raised?
Lordship, this is the third bail application. First was dismissed by the coordinate bench, but as per the new order and direction of Honorable Supreme Court in Jani, this case, all the matters of this FIR has come
So
before this honorable.
at any point of time, this petitioner has been released on interim bail.
No, my lord. No, lordship. He is in jail from March onward, lordship, from the 7th March.
Earlier, this address was verified. Mr. Mr. Sam Manohar, Land Counsel, appearing through virtual mode, and Land Counsel for the state. Land Counsel submits that the petitioner is in judicial custody since 7/3/2021. And what is the stage of the trial?
Lordship, out of 16, 6 has been examined as per the last instruction, lordship.
Out of 15 charge sheet witnesses, 6 witnesses have been examined. And in view of the delayed disposal of the trial, the bail application of the petitioner may be favorably considered. Learned Counsel for the state has earlier verified the address of the petitioner as given in the cause title of the bail application and found it to be correct. Learned Counsel for the petitioner furnished the names, address, and documents of 2 local sureties to the Learned Counsel for the state as per the order of this court. And today the Learned Counsel for the state has produced the written instruction received from IIC Mathili Police Station dated 29/3/2024, wherein it is indicated that the Aadhaar card and the ROR of the local sureties were verified, and it was found that the documents are genuine and correct, and the local sureties are also willing to stand surety for the petitioner. Why it is mentioned that the petitioner Sandeep, if granted bail to him, petitioner is not Sandeep. Petitioner is one.
Petitioner is Mr. Vikas Dahiya, lordship.
Mr.
Yes,
Tripathi.
Yes.
Have you got a copy of this?
Yes.
You see that last line? They are also willing to stand as surety for the petitioner Sandeep if bail is granted to him. Sandeep is not the petitioner here. And this instruction is which has been sought for in this particular bail application.
Yes.
Is it been wrongly typed, perhaps?
Yes.
All right. Learned Counsel for the state submits that though inadvertently it has been mentioned that the sureties are willing to willing to stand as surety for petitioner Sandeep, but the petitioner's name is Vikas Dahiya and inadvertently it has been mentioned to be Sandeep. It is further mentioned in the written instruction that on verification of the criminal antecedent, it was found that there was no criminal cases pending against any surety. Considering the submission made by the Learned Counsel for the state, however, opposed the prayer for bail on the ground that commercial quantity of ganja has been seized from the petitioner, and in view of the bar under section 37 of the NDPS Act, he is not entitled to be released on bail. Considering the submission made by the Learned Counsel for the respective parties, the quantity of ganja seized from the possession of the petitioner, the bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody for more than 3 years and the slow progress of the trial, I am inclined to release the petitioner on interim bail for a period of 3 months, subject to condition that Pritish Bain and Hari Haldar shall be the two local sureties for the petitioner. In Nandita Jago dekhi select. All right, allowed disposed of.
My lord, I am deeply obliged, Lordship.
Item 38.
Yes, Mr. Joshi.
Yes, item 38, 39, and 40. I pray for Thursday, my lord. CD is to
you
Lordship directed for CD.
Uh,
I pray for Thursday, my lord.
Okay, it will come on 5th.
My lord.
5th April.
Yes.
So, as prayed for by the Land and Council for the state, in order to avail the case diary, put up this matter on 5th April 2024. Hai na? Same order in 39 and 40.
The interim order to continue.
Interim order to continue. 5/4/24, 5/4/24, and
Obliged.
5/4/24. Yes.
Item 41.
May I please, your lordship? Say anticipated bail application, my lords.
It was earlier rejected by me or?
No, it was by Honorable Justice S. Pujari.
Okay.
First half, second half order was passed as because this petitioner is a military person, my lord. He was unable to surrender on time and that was lapsed. And that after, my lord, some of the co-accused have been granted bail in this case by another coordinate bench. This is the order, my lord. 6 persons have been granted bail. In ABLPL 6151 of 2020.
So you have got the case diary?
Yes, ma'am.
So what is the material?
Material, lordship, in this case, the present petitioner along with others, they enter into the house of the informant, ransack the house, take 2 lakhs rupees from their house, and also try to assault a 4 months child. That is the allegation, but as per the injury report, there is no mark of injury on the child as well as on the informant. And so far, antecedent in confinement, there is no antecedent.
No, he said that his bail application was earlier, he was directed to surrender and move for bail. But he said that some of the co-accused persons have been granted bail. That is in ABLAPL number 6151 of 2020. So have you verified whether have you give him a copy of that order? Whether the petitioner is similarly situated or not. ABLAPL number 6151 of 2020 and the order is dated 28/3/2022. It is uploaded in the
Yes.
So you can get it and the names of the person will be there. Here it is made as and others.
My lord, the other person, my lord, Londa Jena, Krishna Jena, Sitaram Jena, Jagavan.
How many persons were released on bail?
6, my lord.
6
in this particular bail application.
All right. So get those and verified.
I have given the antecedent.
I'm keeping it. Land and Council for the petitioner has it AG file kale. So why the seal does not indicate the date? Who is to be responsible? on 8th of April 2024. Rest of the matter after lunch.
Adjourn to my lord.
8 at 30.
Please.
Yes.
Item 43.
Last topic is the lordship specifically ordered to serve a copy, extra copy. We have served copy to the government. Copy. Receipt.
What is the CRLA for?
CRLA for release of the vehicle, my lord. March we have served.
Yes, that was the order.
Yes.
That State Council submitted that he is not having the copy of the appeal memo.
Yes.
And you are asked to serve a copy by 21st March 2020.
19th March we have served.
19th March they have served, not tagged. Well, let it come next week.
All right. The Learned Council for the appellant submits that as per the order dated 19/3/2024, copy of the appeal memo has already been served in the AG office. The Learned Council for the state, on the other hand, submitted that the same has not been tagged to file. The matter may be taken up next week. Put up this matter on 8th April 2024.
Item 44.
Switch off, Ajiki.
I am appointed through legal aid, but the brief has not been supplied with. I will collect this.
What is this CRLA for?
I have not supplied the
Conviction, my lord. Challenge the conviction order. 10 years conviction.
You have filed your VINA mark.
No, my lord. I was not intimated, but my name has been reflected. I will collect the brief from thereafter file the brief.
Okay, it is mentioned in the order sheet that because the Parija has been okay. So Jane Panda's name will not be reflected in the since Mr. Vikas Chandra Parija has been engaged by the as the counsel for the appellant through legal aid, the name of Mr. Jane Panda shall not be reflected in the cause list. Let a copy of the appeal memo along with the impugned judgment and copies of the miscase be served on Mr. Parija by the registry by Friday, that is 5th of April 2024. Put up this matter in the week commencing from 15th of April 2024 for consideration of the application for condonation of bill.
Item 45.
May I please, Your Lordship? This appeal has been filed by State Vigilance against the rejection order of the London Trial Court under Section 452, my lord. DA case, and an application was filed before the London Trial Court for confiscation of the property so found to be the including DA amount. So the order was rejected. This respondent has already filed CRL number 199 of 2016, my lord. So may I pray this may be tagged with that whatever order will be.
What is the status of that criminal?
That has been admitted on 2/5/2016 by your lordship.
Yeah.
Admitted, bail granted, in state on 2/5/2016.
No, it has not. It is still sub judice.
Still, yes. So it may be this.
This particular CRLA has been filed challenging which order?
30/5/16, 30/4/16. One-sided copy just now I filed. The defect, it has been reflected in the cause list. One-sided copy not filed. I just filed it.
Yes.
30/4/2016.
The London Council for the.
And both the names may be deleted. My name may kindly be reflected in the cause list.
Achha. Mr. Sanjay Das, London Council for the Vigilance Department, submit that he is to argue this matter. In view of such submission, let his name be reflected in the cause list. The names of Mr. Sangram Das and Mr. Simon Das shall not be reflected in the cause list henceforth. Stop. Mr. Das files the impugned order dated 30/4/2016. One-sided copy, which is taken on record. Land Council further submits that this CRLA has been filed by the State of Orissa Vigilance Department challenging the order dated 30/4/2016 passed by the London Special Judge Vigilance Balashore in VGR case number 14 of 1996 in rejecting the petition under section 452 CRPC, which has been filed for confiscation of the property to the state of Orissa. The London Council further submits that the respondent Vijay Kumar Hui faced trial in the court of London Special Judge Vigilance Balashore in Vigilance trial number 242 of 2007 oblique VGR case number 14 of 1996 for offense punishable under section 13(1)(c) read with section 13(2) of the Prevention of Corruption Act 1947 and the London Trial Court by
1988 man.
19 is 47 it is mentioned.
13-1 is
maybe it is the period which goes back to 1988. That is what it is. Yes, it is. Check period is from 80 to 96.
yes, my lord.
So ସେଇଥିପାଇଁ 88 ନ ରଖିକିନି ପୁରୁଣା ଆପଣଙ୍କର ଇଏ କୁ ଚାର୍ଜ ଫ୍ରେମ୍ ହେଇଛି 47.
Yes, yes,
right?
I'm sorry. Now 80 to 96, my lord.
Please come to the paragraph number 1 of the judgment, of the trial court judgment.
Yeah, 47, it has been written, but
see
your
the
lordship may
see,
kindly.
see the check period.
Check period is
1980 to 1996.
96. So 96 is 88 comes. So thereafter, charge sheet has been submitted, my lord.
Whatever it may be, perhaps the charge has been framed under this 47 Act. Whatever it may be, the London Trial Court by impugned judgment and order dated 33/2000.
By mistake, it has been
16. Found the appellant guilty. Under the offences charged and passed substantive sentence of 1 year and to pay fine of rupees 10,000 in default to undergo RI for 2 months. Land Council further submits that challenging the conviction judgment, the respondent has preferred criminal appeal number
199 of 2016.
199 of 2016 before this court, which has already been admitted, and he has been granted bail, and realization of fine amount has been stayed. And in the fitness of things, this criminal appeal should be heard along with CRLA number 199 of so on.
Why I'm submitting, my lord? In 1947, 51E was there for disproportionate asset. In 1988, it was 13-1E.
Whatever it has been written, so take down that put up this matter along with so on. So,
199 of 2016. Copy is today's copy.
Yes. Oh, yeah, 199. 16. Yes.
Item 46. May I please, your lordship? My lord, the appellant has been convicted under section 376D of IPC and sentenced to undergo RI for 20 years and a fine of rupees 20,000 in default to undergo RI for 1 year under section 376D. He has been languishing in jail custody since 14/9/2013. He has undergone more than half of the sentence, my lord. And PW1 is the victim.
Have you brought that custody certificate?
No, madam. I will obtain it. No direction.
And why you have filed an application for interim bail? You have filed an application for bail, and again another application. It is pending since 2021 for interim bail. So don't praise this application.
My lord.
Focus on that. Look on the IN number 370 of 2021. This is an application for interim bail. The London Council for the petitioner does not want to praise this application. Accordingly, IA is disposed of. Now, IN number 2012 of 2023. This is an application for bail. Land Council appearing for the petitioner submitted that the petitioner is languishing in jail custody since 2013. And therefore, he has already undergone half of the substantive sentence imposed by the London Trial Court. Let the London Council for the state produce the custody certificate. Which jail? Tell him.
Bhubanesh. Bhubaneswar jail.
Vinama, yes, Vinama, it has been signed from Khurda. So must be in that. Let's see that whether assistant jailer Khurda sub jail, it's not Jharpada. So the take proper instruction and tell Mr. Tripathi.
My lord.
Otherwise, because the Vinama has been signed from Khurda sub-jail.
My lord.
If you are saying Bhubaneswar, it is Jharpada. So it's not there. So take proper instruction. Yes. And this matter should come along with the other items, CRLA number 65 of so and so. Okay.
Custody certificate.
Only custody certificate.
Settle.
No. There is no interim application there.
No.
This interim application has been filed only in the first one, 510 of 2016. Right. Okay, so you are to obtain in respect of that Santosh Sahu. Yes.
Obliged, my lord.
Item 47.
47, my lord. I am for the appellant. And IA number 1564 has been filed to condone the delay, my lord. There was only 10 days delay, my lord, to file the appeal.
14 days, madam. So what is this conviction case?
No, it is a matter under OPID Act, my lord.
Okay. So any notice has been issued to the
Supervised notice is issued and the defect was removed, my lord, and notice is issued, my lord.
Just
And
let me see. Let me see that. 1, 2, 3, 4. The last order is order number 5 dated 19/3/2024. And till that date, no notice has been issued on condonation. So when it was issued?
My lord, on last date.
Madam, last date is 19/3/2024 or thereafter it has come?
No, after 93/24, it has come. It has urgent to urgent to today, my lord.
Today, so that means no notice has been issued. So there are some other parties. It is not that only state of Orissa is a party.
Other parties.
There are state of Orissa is opposite party number 1. But there are as many as
all are proper.
35. Maybe so. Notice has to be issued. Why have you implemented them? They have a right to oppose the application for condonation of delay. How without hearing them the delay can be condoned?
No, I'll notice.
IA number, miss case number 1564 of 2016. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 14 days in preferring this criminal appeal. Issue notice on the question of limitation. The Learned Counsel, Mr. Patral and Counsel, Special Counsel appearing for the State of Orissa in OPID Act matter, has already entered appearance and received the. You have received the copy of the appeal?
No, not
Today in course of the day, I'll
stop. Let a copy of the appeal memo along with the impugned judgment and copy of this case be served on the Learned Counsel for the state. Requisites for issuance of notice on respondents number 2 TO2 35 we filed. Some other 1 week within
1 week.
Within 1 week, put up this matter for consideration of the miscase for condonation of delay after the notice is made sufficient. Yes.
Obliged.
Item 48.
May I please, your lordship? Here, my lord, appeal number 2, file IA number, my lord, 580 of 2024 for bail, and my lord, out of 10 years imprisonment,
one accused has not surrendered.
That's not son, but considering the same, my lord, kindly have a glance on my IA. I include the order, my lord, on 13/2/2024. Surrender. My lord, granted in
this report has been received from the Learned Trial Court.
Yes.
And it is mentioned that the convict Ananda Nayak was released on interim bail for 3 months and he did not surrender.
In spite of
that, my lord, grant bail in the appellant number 3, that is, my lord, order dated 3/2024. I also, my lord, annex that, my lord, order, my lord, that is running page, my lord, 8 of my IM. Since, my lord, out of, my lord, 10 years.
So problem
Yes,
is not that grant of question is that you are availing the interim bail, not surrendering. That is not you means the
Anand Naik.
Anand Naik. So you are a man from which area?
My lord, full band, my lord.
So what is the period you have remained in custody?
8 years, 9 months.
Out of
10 years. ତାର ଯାହା ମିଲ order ସେଇଥିରେ ସମାନ।
And have you not ever been released on interim bail?
Interim bail ଯାଇନି, custody certificate my lord may confirm interim bail ଯାଇନି।
No. Since this is the only application you have filed,
my lord may call for the custody certificate. In respect of other my lord also
2018 I have rejected it.
Yes.
Then all right, take down item number 48, IA number 580 of 24. This is an application for bail of appellant number 2. Where is the appeal memo? Arun Sahani.
Arun.
Land counsel for the petitioner submitted that out of 10 years of substantive sentence imposed by the Land Trial Court, the petitioner has already undergone 8 years of sentence. Let the Land counsel for the state produce the custody certificate of appellant number 2, Arun Sahani, put up this matter in the week commencing from 15th April 2024. Give the where he is now. Who jail Ashidam Kundu?
Both jail.
Mr. Tripathi, note down. All right.
Item 49.
May I please look?
Second bail application, second criminal application, second item, my lord.
Yes, that is CRLA number 559 of 2007.
I filed bail application.
Huh?
Out of 10 years, he has already 8 years custody. Initially, 3 months he has gone for interim bail on 21/3/22.
It's a NDPS Act, man. Commercial quantity. So what is the sentence imposed?
Sentence imposed 10 years.
10 years. So how many years you have remained in custody?
8 years.
8 years. Once you are released on interim bail.
Interim, 3 months.
Which order? Order dated?
21/3/22.
Huh?
21/3/22.
No, 21/3 रे किसी order ही नहीं. देख ले 21/3 रे. An order is 21/3 रे.
Yes. IA number 166.
Just a minute. In that I have observed that out of 10 years you have already undergone 6 years. Okay. Then did you surrender at right time?
Yes. Even surrender certificate.
I called for a report from the, since on the next date you did not appear. So it is now 8 years. 8 years होची, But since that 3 months has to be excluded, then your custody period would be 7 years and 9 months, right? What do you say? Are the learned counsel for the petitioner and counsel for the state? This is CRLA number 559 of 2017, IA number 139 of 2024, an application for bail. Considering the submission made by the learned counsel for the petitioner, that the petitioner was taken into judicial custody on 4/3/2016, and he was never released on bail during trial, and this court granted him bail by the order dated 21/3/2022 in Miss Case number 1459 of 2017, and after availing the same, he surrendered at right time, and at present he has already undergone 7 years and 9 months of sentence out of 10 years of substantive sentence imposed by the learned trial court. And after hearing the learned counsel for the state and keeping in view the ratio laid down in the case of Mohammed Muslim, and since the case is not ready for hearing, I am inclined to release the petitioner on bail allowed. Obliged.
Item 50.
May I please? Your Lordship was pleased to call for the custody certificate from the jail, my lord.
Which order?
Item
Last
50,
order.
item 50, my lord.
Yes, Mr. Heller, I have opted. What is the period? Period is what is the sentence supposed to
20 years.
20.
8 years, 8 months.
Have you ever been released?
No.
No. What is the offense here?
Offense 376D, my lord. But the doctor's opinion is not matching, my lord, as per the allegation.
376D20.
But on the last occasion, my lord, the custody certificate was produced, and the CA was called for. Why was the interim bail, my lord? The criminal records was called for.
Custody certificate indicates 7 years, 3 months.
3 months.
That is the dated. What is the date of the custody certificate?
Of 10 years, my lord, 7 years, 3 months.
So perhaps it is March, 14th March. That is the last date given in that custody after conviction. So 10 years to 7 years around. How এটা কোনটা?
He had not misutilized the liberty when he was on interim bail.
On 2 occasions, were granted interim bail, my lord, joined for the court, my lord.
Right, hard. IA number 32 of 2024. Hard Mr. Rautral and counsel appearing for the sole appellant.
Sole appellant.
For the petitioner and land counsel for the state. Land counsel for the petitioner submit that out of 10 years of substantive sentence imposed by the land and trial court, the petitioner has already undergone 7 years and 3 months of sentence. And there is no chance of early hearing of the appeal in the near future. Since paper book has not been prepared, and therefore the bail application may be favorably considered. Land counsel for the state has produced the custody certificate, which is taken on record. He has also produced the written instruction received from IAC Monmunda Police Station, dated 2/4/2024, wherein it is indicated that during the period of interim bail, the petitioner has not violated any terms and condition nor misutilized his liberty. Considering the submission made by the land counsel for the respective parties, the sentence imposed by the land and trial court, the period already undergone by the petitioner in judicial custody, the conduct of the petitioner in complying with the terms and condition of the interim bail order, and also keeping in view the ratio laid down in the case of Muhammad Muslim, I am inclined to release the petitioner on bail allowed.
Obliged.
Item 54.
Madam, on behalf of S.K.SAHOO, with
Item 57.
My lord, I'm here for the petitioner. My lord, in the last occasion, the state was granted with further time to obtain instructions regarding the conduct of the petitioner while he was on bail for 3 occasions.
As far as the interim bail on each occasion petition, okay. Misutilize the liberty or during the interim bail. कौन है ना
This matter will be taken up day after tomorrow.
day after tomorrow. So it will come on 8th of get it. The Land and Council for the state seeks some more time to obtain instruction as per the order dated 27/3/2024. This should be in IA number 431 of 2024. This is an application for bail. Put up this matter on 8th April 2024. All right.
Obliged, my lord.
Item 58.
Yes, Mr. Panda.
My lord, in this case, I pray on Monday. In the meantime, state be requested to obtain the custody certificate. Out of 10 years, Koraput, district Koraput.
IA number so and so stay realization of fine allowed for the Baki IA number so and so this is an application for bail. Submit that out of
5 year 9 months.
10 out of 10 years of substantive sentence. He has already undergone half of the sentence. Custody certificate to be obtained. Put up this matter on 15th April 2024. Stay fine for the Yes.
Item 59.
Mr. Mahapatra.
May I please, Lordship? Here the appellant is convicted under section 20B2C and 27A of NDPS Act, my lord. And the imprisonment period is 10 years, my lord. Last occasion, the Honorable Court directed to obtain the custody certificate, my lord.
No, Mrs. Sahu.
My lord.
This indicates that 29/4/2019 ରୁ ସେ ଥିଲା ଆପଣଙ୍କର ମାଲକାନଗିରି ଜେଲରେ
My lord.
ତାପରେ କୋରାପୁଟକୁ ପଳେଇଲା 29/8/2021 କୁ
My lord.
29 ଆପଣ କୋରାପୁଟରୁ ମଗେଇବେ ତାପରେ କଣ ହେଲା ସେଠୁ କୋରାପୁଟରେ ତା ପରେ ଯଦି ବେଲରେ ଯାଇଛି କି କଣ ହେଇଛି କି ଜାଣିଛି
My lord.
ବୁଝିପାରିଲେ ତ ତେଣୁ ଏଇଟା ଆପଣ ଯୋଉ ଆଣିଲେ ଇନଫର୍ମେସନ ଇଟ୍ ଇଜ ନଟ୍ ଦି ଫୁଲ ଇନଫର୍ମେସନ ୟୁ ଆର୍ ଟୁ ଏଗେନ୍ get the information.
Circle jail Koraput.
ଏଠି କଣ କି ଏଠି ମାଲକାନଗିରି ବାଲା ବି ଯଦି ମଗେଇ ଦେଇଥାନ୍ତେ ତାଙ୍କଠୁ କୋରାପୁଟ ଜେଲରୁ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣି ଏକାଠି ପଠେଇ ପାରିଥାନ୍ତେ ସେ କେବଳ ତାଙ୍କ ଇଏଟା ପଠେଇ ଦେଇ ଛାଡିଦେଲେ
Lordship, in the second matter submit 2, I am appearing for appellant number 2 and 3, Lordship. On the last occasion also, custody certificate was also obtained.
ଏଇଟା ସରୁ ଆଗେ ଦିଲ୍ଲୀପ ରେ କଣ କେତେ ଜଣ ଅଛନ୍ତି single appellant
CRLA 513.
CRLA number 513 of 2021. First application is IA number 930 of 21. Stay of realization of fine allowed. Then this IA number 931 of 2021. This is an application for bail. As per the order dated 23/2024, the Land and Council for the state has received the custody certificate from Superintendent District Jail Malkangiri, which is dated 23/3/2024, from which it appears that the petitioner was taken into custody on 29/4/2019, 29/4/2019, and he was transferred to Circle Jail Koraput on 29/8/2021. Stop. The custody certificate is taken on record. Land and Council for the state submits that she may be given some further time to obtain the custody certificate from the circle jail, from the superintendent circle jail, Koraput. As prayed for put up this matter on 15th April 2024. Free copy of the order be handed over to the Learning Council for this time. So, yes, Mr. Mahanti.
Yes, Lordship. In
Acha,
PRLA number
CRLA
514 of
number 514 of 21 sterilization of fine jota achi seta allow kar debe 933 of 21 932 of 2021 ta dhyan chandi
Same, but same. Jaja same
Same.
again.
cb gola circle jail
Again.
He's in custody since 1905
wait
2008.
adire ke jano chandi
Lordship, 3 persons. Am I
3
appearing on?
person ଏଗୁଡ଼ା ସବୁ ଏদের ସବୁ ଟ୍ରାନ୍ସଫର ହେଇଯାଇଛନ୍ତି ସେଠି ସେଇ ସବୁ କୋରାପୁଟ ଜେଲରୁ ଯାଇଛନ୍ତି ସେଠୁ ମଗେଇବେ ଆଉ ହେଲା ଲାଷ୍ଟ ଲାଇନ ଦେଖୁଛନ୍ତି ସେମ୍ ଡେଟ୍ ତାକୁ so this matter will come again on 15th of so custody certificate of A1 TO2 A3 yes next
Item 60. Item 66.
Mr. Panda.
Item 66, I pray, my lord, that to be taken up 1 week after. Mr. Panda is on his legs.
Mr. Sudipto Pandal and counsel appearing for the appellant seeks for an adjournment for 1 week. Put up this matter in week commencing from 15th April 2024. Yes.
Item 67.
May plus. Last order matter 11/3/2024. Lordship directed to call for the CA of the active person.
Yes, sir. ହେଲା ଆଉ ଏଇଟାକୁ after summer vacation ପାଇଁ yes next
Item 74.
yes
Wait, please. Here, my lord, the present appellant has been convicted for the offence under Section 7 of the Prevention of Corruption Act and has been sentenced to undergo RI for 3 years and to pay a fine of rupees 5,000. My lord. The present application is valid under Section 389 for suspension and stay of conviction passed by the learned special judge Fulbani, my lord. My lord, here the allegation as FIR, my lord. LCR has come, my lord. We kindly see the FIR. I want to draw my lord's attention to the FIR because that goes to the root of the case.
The trial produce yes
My lord, may I read better the FIR? My lord, FIR is like this. ଆମ ଟିକାବଲି ବ୍ଲକରେ 4 ଜଣ ଲୋକ କୁନ୍ତିମାଳା ପ୍ରଧାନ, ଇନ୍ଦିରା କହଁର, ନିରୋଧ ପ୍ରଧାନ, ଗଜପତି ପ୍ରଧାନ ଓ ସେମାନଙ୍କର ମୃତ୍ୟୁକାଳୀନ ସହାୟତା ଯାହାକି 1 ଲକ୍ଷ ଟଙ୍କା ଏବଂ ଅନ୍ୟାନ୍ୟ ସାହାଯ୍ୟ ପାଇବା ଫର୍ମ ସହିତ ଅନ୍ୟାନ୍ୟ ଦରକାରୀ କାଗଜପତ୍ର ଯଥା ମୃତ୍ୟୁ ସାର୍ଟିଫିକେଟ, ଲେବର କାର୍ଡ, ଆଧାର କାର୍ଡ, ବ୍ୟାଙ୍କ ପାସବୁକ୍ ଇତ୍ୟାଦି ଦେଇଥିଲେ। ସେହି ଫର୍ମକୁ ମୁଁ ପୂରଣ କରି ଲୋକମାନେ ଦେଇଥିବା ଆବଶ୍ୟକୀୟ କାଗଜପତ୍ର ସଂଲଗ୍ନ ତଥା ଗତ 1/11/2019 ତାରିଖରେ ଜିଲ୍ଲା ଶ୍ରମ ଅଧିକାରୀ ଫୁଲବାଣୀଙ୍କ ଅଫିସକୁ ଯାଇଥିଲି। Madam, kindly take note of 1/11/2019. We had gone to the office of district labor official. ସେଠାରେ ଜିଲ୍ଲା ଶ୍ରମ ଅଧିକାରୀ ଶ୍ରୀ ରଞ୍ଜନ କିଶୋର ବେହେରାଙ୍କୁ ଭେଟି 4 ଜଣ ଲୋକଙ୍କ ଫାଇଲ ଦେଇଥିଲି। ଉକ୍ତ ଫାଇଲକୁ ଦେଖି ଶ୍ରମ ଅଧିକାରୀ ଶ୍ରୀ ବେହେରା ମୋତେ ସେହି ଲୋକମାନେ ଆସିଛନ୍ତି କି ବୋଲି ପଚାରିଥିଲେ ଏବଂ ଫାଇଲ ପ୍ରୋସେସିଂ କରିବା ପାଇଁ ଜଣକ ପିଛା 8,000 ଟଙ୍କା ଲାଞ୍ଚ ଦେଲେ ସେ ଫାଇଲ ରଖିବେ ଏବଂ ତଦନ୍ତ କରିବା ପାଇଁ ନିର୍ଦ୍ଦେଶ ଦେବେ ଏବଂ ଫାଇଲ ପ୍ରୋସେସିଂ କରିବେ। ଲାଞ୍ଚ ଟଙ୍କା ନଦେଲେ କିଛି ହୋଇପାରିବ ନାହିଁ ବୋଲି ରୋକଠୋକ ମନା କରିଦେଲେ। ମୁଁ ତାଙ୍କୁ ଲୋକମାନେ ଗରିବ ଅଟନ୍ତି ଓ ଏତେ ଟଙ୍କା ଲାଞ୍ଚ ଦେଇପାରିବେ ନାହିଁ କହିବାରୁ ଶ୍ରୀ ବେହେରା ବାବୁ ଜଣକ ପିଛା 4,000 ଟଙ୍କା ହିସାବରେ 16,000 ଟଙ୍କା ପ୍ରଥମେ ଅଗ୍ରିମ ଭାବରେ ଲାଞ୍ଚ ଦେବାକୁ ପଡିବ ବୋଲି କହିଥିଲେ। ମୁଁ ଲୋକମାନଙ୍କ ସହିତ କଥା ହେବା ପରେ ଆପଣଙ୍କୁ ଜଣାଇବି କହିଥିଲି। ଏମିତି 1-2 ଦିନ ବିତିଗଲା ତାପରେ ପୁଣି ଆସି 6/11/2019 ତାରିଖରେ ପୁଣି ଥରେ ବେହେରା ବାବୁଙ୍କୁ ଭେଟି so and so my lord. This informant complainant's decoy my lord has been examined as PW4. He has given a complete go by to the story of 1/11/2019. And my lord, the peculiarity of the case is, my lord, the charge which has been framed by the learned special judge, he has also not stated about this charge. My lord, we kindly see the charge. Kindly see the charge.
yes
Charge date is 24th June 2022.
I'm having that charge.
My lord, firstly, that you being a public servant employed as district labor officer Fulbani on 7/11/2019 at about 2:45 p.m. in your office chamber at district labor office Fulbani demanded and accepted a sum of rupees 15,000 from the complainant Sri Babuja Pradhan, son of so and so, resident of so and so, as gratification other than legal remuneration, as a motive or reward for the improper or dishonest performance of a public duty, such as in order to scrutiny and process the documents and to recommend the file of 4 numbers of beneficiaries.
No, what do you say? How it is different?
This charge is lack of this 111.
No, 111, the 111, that was the initial date demand was made.
Yes,
But this 711,
My
it
lord.
was further demanded and
My lord,
accepted.
that my lord has considered. Why I am tempted to go instead of going to the merit of the case. In the recent order, my lord which my lord has pleased to pass in criminal appeal number 208 of 2019. This aspect has been considered. Without going to the merit of the case, my lord was pleased to allow the application. So for that reason, I was.
No, you are making a submission,
my lord,
that the FIR, you see, FIR was lodged on 6/11/2019.
My lord.
And FIR indicates about the demand which was made on 1st
111. My lord.
So obviously this aspect is not there in the charge.
My lord.
Charge is for the second one after this FIR was lodged. This preparation must have been made, and then they had gone there in the office. There must be some kind of demand and then acceptance, and that is how the charge was framed relating to the incident dated 7th. No charge was framed for 1/11/2019.
Yes. And that and my lord has considered in that order judgment, paragraph in page 8, that though this fact was mentioned in the FIR, that was not found place in the charge. That has weight in my lord's mind, and my lord was pleased to consider it, and referring a number of judgments was pleased to allow the application. There, my lord may kindly see, page 8 of that judgment.
In one case, I state the proceeding, you state the conviction,
my lord,
because he was convicted for a demand of a particular date,
my lord,
for which there was no charge.
Yes.
So if
if the present case will be accepted, demand was made.
Have you been convicted for the demand raised on 1st? Then you have a case.
No, here by the demand as per the case on 6th.
Right.
But FIR says the demand was made by the accused or the appellant on 1/11.
FIR is all right, but demand was not only made on 1st, but it is the prosecution case that demand was also made on 7th. 7th, and payment was also made.
Exactly by the same case for which I tried to go through my lord and see this aspect.
No, here let us be clear. We'll go to that case. Here the conviction was for the demand which was
made on
7th or 1st?
7th.
So that portion of the judgment.
Judgment.
Judgment of.
That was the judgment. Yes.
The PC actually amended by 2018 amendment. Yes, so the conviction is also for 7th.
For 7th.
For first, there is no charge, there is no conviction.
Well,
though in the FIR it is mentioned that
initial
first
demand
also the initial demand was
on
that
first.
for on first.
Ballot.
Okay.
That has weighed in the mind of court ballot while considering the earlier case.
Yes.
I'll go bereft of that. I'll go to the merit ballot, which goes to, and no question has been also put. Ballot in the kindly see paragraph 8, sir, page 8 of that judgment. Srihari Charan Das. Paragraph 8, ballot was pleased to quote the charge. Page 8.
Page 8.
Ballot. Ballot pleased to quote ballot the charge. After that, ballot, even though PW1 has mentioned in the first information report that the bribe of rupees 6,000 was demanded from him by the petitioner on 11/6/2013, but in his evidence during trial, he has nowhere stated that on 11/6/2013, demand of rupees 6,000 was made by the petitioner to him. In the charge framed under Section 7 of PC Act, it is stated that on 20th day of June 2013, the petitioner demanded and accepted 6,000 from PW1 as gratification other than legal remuneration as a motive or reward, and thus the dates of demand are quite different. Law is well settled. After that, my lord was pleased to set the law, my lord. The question. But concluding paragraph, my lord also observed, having regard to the aforesaid position, but after that, the law with regards to 389, beginning from Sarin to till date.
No, you see, please come to page number 10.
My lord.
Page number 10.
10, my lord.
Just read it out. Therefore, in the absence of any charge,
so also the evidence on record
that on
11/6/2013, the petitioner demanded rupees 6,000 to the complainant as bribe. The finding of the law and trial court in paragraph 29 of the judgment, while convicting the petitioner under Section 7 of the PC Act, the prosecution has succeeded in proving the factum of demand made by the petitioner to the complainant on 11/6.
That is most important.
Valid.
So there, no charge was framed for the demand on 11/6/2013.
But conviction has been made on for 11.
Right. No evidence was adduced, but the conviction was for the demand. So that is how it was observed that when your charge is not there for 11/6, when you are adducing no evidence for the demand on 11/6, how can you convict a person on for the demand on 11/6/2000? But here is a case where there is no nothing about in the charge about the demand on 1. There is nothing, but you have not been found guilty for the demand on
111.
If it would have been there, then this ratio would have been applicable.
Well, bereft of that,
this time we'll take up matter tomorrow. Okay.
Tomorrow,
এটা ରଖିଛି କାଲିକି ନେଇ ଆସିବ
ମୋର ମାଇଲର ଆଫ୍ଟର ଲଞ୍ଚ
ଦିଟା ବେଳେ ନେବା କିଛି ଅସୁବିଧା ନାହିଁ
ଫାର୍ଷ୍ଟ ଆୱାରରେ ମୋର କେତେଟା
ନାଇଁ ଲିଷ୍ଟରେ ଏମିତି ଆସିବ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡିଂ ହେଲା ଦିଟା ବେଳେ ଟେକ୍ ଅପ୍
I am to submit that since 11/3
ଦେଖିଦେବେ ନା of this matter on 3rd of April 2020 matter will be taken up at 2 p.m. ହେଲା
I have already filed my objection, my lord. In the noting, nothing has been indicated. On 11/3/2024, I have filed my objection.
Objection achhi to record.
And today also I have filed one set more.
Event ठीक है. Objection is there. There is no problem. Tomorrow at 2 o'clock.
Copy दिया है जी. सौरभ जी.
अच्छा हो गया